She wishes by filing an application. And she's in no state to deal with that now. We'll get that paperwork. Report for the County of Presqu'île, again, providing public access online and in the courtroom. And Mr. Gilbert, you ready with the sentencing for who?
Miss Day, Your Honor.
All right, this is People versus Lisa Day, file 22-93211FH. I did receive an amended information from the prosecutor. Do you accept, have any objection to that being filed?
None, Your Honor. Thank you.
And we're here for sentencing on charge of attempted fleeing and eluding in the 3rd degree, 2.5-year felony, and reckless driving, a 93-day misdemeanor. You had a chance to review the report and recommendations?
I've reviewed the report and recommendation, Your Honor.
Okay, any additions or corrections?
None.
The advisory guidelines are at 0 to 9. Any scoring challenges?
None, Your Honor.
Mr. Radsabon, any additions or corrections or scoring challenges?
No additions or corrections, no scoring change.
Okay. Mr. Gilbert, go ahead with the allocution.
Yes, Your Honor. Miss Day, and as the court can see, is having a tough time with the recommendation. I do know that, and the court probably doesn't remember or looks in the file, Miss Day is an individual that I did ask for a forensic on. I had a lot of concerns throughout the course of this case that she does have mental health issues. I know she does have a list of prescriptions. And talking to her just now, I guess there's been some prescriptions she hasn't been able to get refilled, and she's having some serious issues with that. There is a mental health issue, a component to this case, and I believe that's really what happened the evening that this happened, was that she was having an episode, and which resulted in her fleeing and eluding the police officers. I don't believe if Miss Day would have been in her right mind at that time that it would have happened. She does have a history of issues with her prescriptions. I would ask the court to consider possibly a length of probation. I'm not really sure how much the incarceration would help or deter in a situation where it was a little bit probably beyond her control due to her mental health issues. So I'd ask the court to take that into consideration and consider possibly no jail. Thank you.
Thank you, Mr. Gilbert. Ms. Day, it's not required that you would make a statement. It is allowed. Is there anything you wish to say or no?
I apologize. And like I said, I don't know what happened. My mind wasn't processing what was going on at the time. And I just can't believe that I did something like this, because it's totally out of my character. And I don't feel that I can continue my treatment if I'm incarcerated. And I need to continue my treatment because it's vital to my mental health.
All right, thank you. Mr. Radsbon, recommendations from the people?
I'm totally in agreement with the recommendation for 9 months in jail. I can't state enough how much of a risk and danger this day presented, not only to the officers involved, but to the public.
This is the legal fulcrum of the case. The prosecutor is no longer talking in abstractions. He is anchoring sentencing to concrete risk. 3 officers run off the road. A high-speed intersection with a recent fatality. A deputy deliberately positioning his vehicle to stop the defendant before something worse happens. In sentencing law, this matters enormously. Even when guidelines are low, judges are permitted, sometimes obligated, to prioritize public safety. Mental health mitigation carries weight, but it does not erase conduct. The prosecution's argument reframes the case. This is not about why she fled, but about what could have happened because she did.
To drive at that type of speed, running 3 officers off the road in order to avoid a collision, blowing through the intersection of M68 and 23 at a high rate of speed. Thankfully, Deputy Woodsford essentially sacrificed himself in his car to get her somewhat off the road before she went running down in the middle of town, and we had another incident in town. We just had a fatality out at that area maybe a couple of months ago. It's a dangerous intersection, Judge, and for her to do what she did, regardless of mental issues or not, she deserves some incarceration. And I really believe that 9 months is open. And insofar as we're getting mental health, I'm sure it can be arranged in Northeast Michigan Community Mental Health while she's in jail to take the treatment. Thank you.
All right, thank you. Well, Ms. Day, you're here for sentencing. It is your first felony. The guidelines are 0 to 9. You did receive some benefits from the plea bargaining process to have it be a lesser felony. But this is a case where then, police are responding to your behavior and, causing a risk to the public, dancing in the roadway and then driving fast. And then you don't stop for police. You're at over 100 miles an hour. Running vehicles off the roadway, not only law enforcement, but just ordinary folks.
That sentence signals the outcome. When a judge uses the phrase extreme risk to the public, the door to non-incarceration is effectively closed. The court is drawing a clear legal boundary. Diversion works when risk is low. Here, the risk was catastrophic. This is the moment where mitigation gives way to accountability.
I mean, from a case I had earlier today, where appropriate, if there's a way to divert to the mental health system, that can work sometimes. And in that case, it was a resisting arrest that wasn't super active resisting, and there wasn't really a great degree of risk to the officers, let alone the public. In this case, this is a case of extreme risk to the public and to those law enforcement officers. I agree with the statement in the report. It's fortunate that nobody was killed. And Ms. Day compounds the mental health with the substance abuse problems as well. I think that extreme risk to the public from this situation does warrant some incarceration. Given the total circumstances, I am going to adopt that recommendation in order that Ms. Day serve 9 months in the Prescott County Jail with credit for 4 days previously served, 93 days on the misdemeanor count, again, credit for 4 days, state costs of $118, and the crime victims assessment of $130. And Ms. Day can file an appeal if she wishes by filing an application. And she's in no state to deal with that now. We'll get that paperwork.
You guys don't know nothing about mental health.
This case began as a sentencing hearing, but ultimately became a textbook example of how courts balance compassion with responsibility. Lisa Day appeared before the court on convictions for attempted fleeing and eluding in the 3rd degree, a felony, and reckless driving, a misdemeanor. The advisory sentencing guidelines range from 0 to 9 months, giving the judge broad discretion. That discretion, however, had to be exercised in light of the facts placed on the record. The defense focused heavily on mental health. Counsel explained that Ms. Day had long-standing mental health issues, relied on multiple prescriptions, and had recently been unable to obtain refills. According to the defense, the incident that led to these charges occurred during a mental health episode, one so severe that Ms. Day was not fully processing reality at the time. The defense argued incarceration would interrupt treatment rather than help, and urged the court to impose probation instead of jail. Ms. Day herself echoed that theme. She apologized, expressed disbelief at her own actions, and told the court she could not understand how she behaved the way she did. Most importantly, she emphasized that continued treatment was vital to her mental health and suggested jail would undermine that progress. Her statement was brief, emotional, and consistent with the defense narrative. This was not criminal intent, but crisis behavior. The prosecution did not dispute the existence of mental health issues, but made clear that they could not outweigh the danger of the conduct. The prosecutor detailed a high-speed chase involving speeds exceeding 100 miles per hour, officers being forced off the roadway, and a dangerous intersection where a fatal crash had recently occurred. One deputy, according to the record, deliberately intervened with his vehicle to prevent the situation from escalating further. The prosecution argued that regardless of the cause, the risk created was severe, ongoing, and unacceptable, and that incarceration was necessary both for accountability and public protection. They also noted that mental health treatment could still be provided while in custody. When the judge delivered the ruling, the reasoning was methodical and clear. The court acknowledged this was Ms. Day's first felony and recognized that plea bargaining had already reduced her exposure. The judge also recognized that mental health diversion can be appropriate in some cases, and even referenced another case from earlier the same day where diversion was justified due to minimal risk. But the court drew a sharp distinction here. This was not passive resistance or low-level misconduct. This was extreme risk, high speeds, fleeing police, endangering officers and civilians alike. That distinction controlled the outcome. The judge concluded that the danger to the public required incarceration and adopted the prosecution's recommendation. Ms. Day was sentenced to 9 months in a county jail with credit for time served, along with the associated misdemeanor sentence, costs, and victim assessments. The court also advised her of her right to appeal. Legally and socially, this case underscores a critical reality. Mental health can explain behavior, but it does not automatically excuse it, especially when lives are placed at risk. Courts are increasingly sensitive to mental health issues, but they remain bound by a core responsibility to protect the public. When those interests collide, risk becomes the deciding factor. If you found this breakdown helpful, let me know what you think about how courts should balance mental health treatment and public safety in cases like this. And don't forget to like, subscribe, and follow for more courtroom analysis.